live. We're about to discuss all the latest updates in US immigration. As usual, we don't have too much time, so we will get started momentarily. But please, if you can see me and hear me, great. Type USA or just drop the US flag in the comment. Let me be sure that everybody across the various platforms can hear me well. Please drop USA, USA, USA if you can hear me and see me real well. We're going to be discussing a number of very interesting topics. You guys want to stay tuned until the end. We have so much to discuss. The rate at which Trump is giving us back-to-back updates means that we have to keep up. So there's a lot to cover today. If you can hear me and see me well, please drop USA. I cannot see anything from Facebook or LinkedIn, YouTube. I only see for Instagram and even TikTok. I don't see anybody dropping USA yet. Please drop USA and let's be sure that you guys can see me across all the platforms. And you can start sharing your questions. Once we're done with our discussion, we'll answer a few questions to see how we can assist. Okay, we obviously will not be going into great detail because a lot of the times we have to understand the particularities of your case before we can give proper legal advice. So take this as a general form of education. All right, let's start with the first thing, neighborhood investigations for US citizenship applicants. Or naturalization applicants, I should say. I'll be sharing my screen as always on Facebook, LinkedIn, YouTube. So there you go. Let's see, is this the right one? Yes, this is the right one we have. So this memo was released on August 22nd, 2025, and the memo is the one that says that USCIS is bringing back naturalization interviews, personalized, I should say, because naturalization interviews never went away, but this time they are including something extra, personal investigations or neighborhood checks, or what we call neighborhood investigations. Let's start with, let me start by sharing well, before we get to the statutes, let's just go over what the historical timeline is. So from 1802 to 1981, those who were applying for naturalization or US citizenship through the process of naturalization, they were required to present two witnesses who could testify that the people qualified for citizenship. Okay. Now, let me go back and say that naturalization is where you are a citizen or a national of another country, and then you become a lawful permanent resident. And then after the age of 18, you apply for US citizenship. You have to go through the rigors of US citizenship application. You submit an application with supporting documents, and then you go through the testing, the civics and the English test, and then you'll go through submitting your biometric, your biographic information, your name, where you live, and then you go through an interview by an officer. They'll find out about your criminal history and things like that. But this is different, right? So you go through that, and then at the end of the day, you take something called an oath of naturalization, and then you become a US citizen, a naturalized US citizen. Now, with this new thing, they are looking to add neighborhood investigations. And again, it's not entirely new because it existed in the past. They just stopped it for some 34 years. And so between 1802, so between 1802 to 1981, those who were applying for naturalization, you had to present two witnesses, and they'll say, oh yeah, this person qualifies, this person pays his taxes, he's a good member of society, and whatnot. In 1981, Congress eliminated or removed the requirement for witnesses. So, it sounds a little self-serving. If you're applying for citizenship and you can bring your own witnesses, everybody will bring a witness that will say great things about you. You're not going to bring your enemy or your frenemy who's going to say this guy is terrible, you know. So it sounds a little self-serving. So it's little wonder that Congress, which is a body that makes laws in the United States, they canceled or they eliminated this requirement for witnesses. They said that a petitioner's character was better determined by an investigation, including a neighborhood investigation if necessary, instead of bringing, letting everybody bring the people that love them the most. Because if you ask me to bring witnesses, I will bring somebody who has great stuff to say about me. By 1991, however, the former Immigration and Naturalization Service, INS, they had essentially stopped conducting the neighborhood investigations. So now USCIS says we're bringing it back. This was stopped in 1991, but we're bringing back personal investigations under law. Now, let me share the statutory basis upon which this rule relies on. Let me share this right here. I'm sharing this from our Facebook page. We shared the statutes right here. You go to INA, the Immigration and Nationality Act, section 335.1. It says, the main title of the section is Examination on Application for Naturalization. It says that subsequent to the filing of an application for naturalization, the service shall conduct an investigation of the applicant. It means that after you file your naturalization application, then you've given USCIS the go ahead to investigate you. This is like a welcome note for them to conduct an investigation into your life and about you. The submission of that naturalization application. Now, the investigation shall consist at a minimum 3 things, meaning even if they don't do anything at all, these 3 things for everybody that applies for naturalization or US citizenship through the naturalization process, USCIS has to do at the barest minimum these 3 things. Number 1, USCIS has to review all pertinent records. What does this mean? It means they have to review your entire A file or your alien file. This is your file that contains information about how you got your green card, which applications you filed, where you live, what you submitted, every single evidence you submitted. If somebody sent a letter to immigration telling them that, oh, this person it has a fraudulent marriage, all of that will be contained in your A file. Any evidence of fraud, misrepresentation, inadmissibility, it will be contained in your A file. That alien file is your file that has your entire immigration record. Okay. Now, if you are sent to immigration court, this A file is what the DHS will pull up from USCIS and use to discredit you or use to help get you deported from the United States. So the A file is a very important file. So the investigation shall consist, number 1, a review of all your pertinent records. Number 2, police department checks. And number 3, a neighborhood investigation in the vicinities or the areas where the applicant has lived, has resided, and has been employed or engaged in business for at least the 5 years immediately preceding or immediately before you file the application. So if you file your citizenship application in 2025, the investigation is going to start from the year 2020. And they're also going to do all these other checks, review of your A file, police department checks. Now it goes on, the section of law under which this is based goes on to say that the district's director may waive the neighborhood investigation of the applicant provided for in this paragraph. And so this can be waived by USCIS. They do not always have to conduct a neighborhood investigation. And we're going to be looking at what you can do to avoid triggering a neighborhood investigation or a personal investigation once you apply for US citizenship. So let's go through the steps. Let me go back to the memo. I'm sharing the memo. Let me go back to, let's go back to the memo that we had. Okay, let's see here. All right, this is the memo, I believe. Okay. Okay. So moving on, there's going to be a three-step analysis, okay, for USCIS to determine should they conduct a personal investigation, should they not conduct a personal investigation. There has to be a three-step thing. The first thing is that when you submit your US citizenship application, USCIS will decide, well, first of all, they will review your entire evidence. They'll review your application, which is your N400 application. They are going to review all the supporting documents that you've submitted with your citizenship application. They are going to be reviewing that. I don't know why I did not use filter. Well, is that too dark on Instagram? Let's see. Okay, let me try this one on Instagram. Okay, so the step one is that they're going to be reviewing your records, your N400 application, submitting supporting documents, all that is contained in your e-file. Then they'll move to step two. Now, step one, if they are satisfied with how proactive you've been, you've submitted more than enough evidence for them to be able to decide upon whether you are somebody who has good moral character, you satisfied all the eligibility requirements, then there should be no problem. Okay, now let me go back and then let's talk about this memo again here. If you look at the memo, it tells you about the fact that there is a purpose for this investigation. They're not just investigating to find out whether you like to eat pizza or something irrelevant. The purpose of the investigation is to corroborate or confirm that you are actually eligible for naturalization. It includes scrutiny of your residency, your permanent residency, where you've lived, how long you've lived in the US, travels, your travel history. Number two, it's in how you, another key thing is how you even obtained your residency. If you're a green card holder, how did you obtain your residency? This is one key fundamental thing they do that shocks people. If you have fraud on your record, these are things that you have to be aware of. They are going to check how you became a US citizen. I'm sorry, you became a green card holder. And sometimes some of these misrepresentations or fraud issues are even, well, I would say misrepresentation issues are unknown to the applicant. Let me give you an example. Some green card or lawful permanent resident categories, when you are coming in on an immigrant visa, you cannot be married before you get admitted. Example, under the F2B category, if you have, or F1 category. F2B category is the adult son or daughter of a lawful permanent resident. You cannot be married before you enter the US, before you are admitted as a permanent resident. If you get married before you are admitted either on F1 or F2B, your lawful permanent residency is deficient, it was not properly procured, and it is invalidated by that act, that single act of marriage, whether or not it was done with knowledge of its unlawfulness or not, whether you know or you don't know. It's your duty to know the law. Neminem juris non excusat. That's a Latin phrase for saying nobody is excused by the ignorance of the law. The law assumes that you know the law, because think about how easy it would be if each time you did something, the excuse would be, oh, I didn't know. Then they say, oh, he didn't know. It's okay. They pat your back and say, okay, bye-bye. You didn't know. Just be safe. No. Because otherwise, they're not going to be able to determine who really knew from who didn't know. Because, Shakespeare said it, and my dad likes to say it. I don't know the exact quote, but you cannot tell the art of the mind's construction from the face. You don't know what somebody is thinking just by looking at their face. So then how will they be able to determine, did this person know she looks guilty? So the law doesn't want to go into the realms of I didn't know and I didn't know, or I knew and I didn't do it, or I didn't know so I didn't do it. So to level the playground for everybody, everybody is presumed to know the law. It is your duty to educate yourself and to know the law, which is why we do what we do, because in that case, in that way, you are able to learn some more about what's happening and what you should know about. So if, for example, you do such a thing, then your residency is already in jeopardy. They're going to look at how you got that permanent residency. If you got married through a fraudulent marriage, that's a problem. They're going to dig into all of that. Some people are able to get away with it. Some people are not able to get away with it. So they'll look at that. The purpose of the investigation is to corroborate how you got your residency, your good moral character. What is it looking like? Do you have criminal records? Sometimes you don't even have criminal records, but you've committed adultery that has broken up a marriage. That makes you ineligible for naturalization, especially if you don't have extenuating circumstances or circumstances that you can show that, oh, this is what happened and it was beyond your control. If you're not paying child support, you're not paying alimony, those are things that don't show good moral character. And now they're also going to be looking at, do you constantly get driving tickets? Every day you are overspeeding. One person, you can get about 6 driving tickets in a year. That's a lot, because the regular good member of society will not be getting 6 driving tickets in a year. There are some people that have never gotten speeding tickets ever in their lives. So you want to make sure that you are doing these things. So that's the second purpose of the personal investigations, to corroborate your good moral character. And number 3, to look at whether you are attached to the US Constitution. Number 4, they'll look at whether you have or you are disposed to the good order and happiness of the United States. This phrase, I said it, it just always makes me laugh. Good, you have to be disposed to the good order and happiness of the United States. You have to make the US happy. You cannot be making the United States sad with your conduct. If whatever you are doing will make the country weep, will make the country cry, then you are not disposed to the good order and happiness of the United States. But if you are paying your taxes, you are working hard, you are volunteering in your neighborhood, at parent-teacher associations, in your church, at orphanages, at rehab centers, you are helping, drive-through volunteer food feeding programs. You are just somebody who is wonderful, making the United States smile. When it's time to pay your taxes, you're paying it. You're paying good taxes. Come on, the US is going to be so happy with you. You are driving under the travel speed, or right on it, right? 25 miles per hour. You're not going 30 miles per hour. All those type of things can show. So that's what the personal investigation or the neighborhood investigation wants to confirm or corroborate. USCIS, they may waive this requirement if you are very proactive in submitting all you need to submit, and they are convinced that, no, this person qualifies for naturalization. So we talked about step 1. They're going to be reviewing your relevant evidence contained in their records. That's all they're going to be looking out for. Number 2, step 2, if your records don't seem sufficient, or there's some lapses, or they feel like, we're still not convinced that this guy is disposed to the good order and happiness of the United States, they can send you something called an RFE, a request for evidence. When they do this, they give you 87 days to typically submit a response to their request. And then, during the request for evidence, that's when you can also decide, oh, okay, let me bring more evidence. Letters, testimonial letters from your neighbors, your co-workers, your business associates, your children's teachers, your church pastor, things like that. So this is the second step. If you don't give them enough information, then they will ask you for evidence. So it's a good time, as I told you guys, to be nice to your neighbor. Don't, when you are going out to take your mail from the mailbox, you frown your face. That's not, you cannot be frowning your face. You have to be smiling, greeting everybody. I mean, because that's what a good, when I remember when I was in Wesley Girls High School, we were taught that everybody you meet, you say hi, hi, hi. You see, and you smile and say hi. As to whether we practice it religiously or not is not the matter, but it's very nice that when you're going, you're walking your dog or you are getting out from your car, you see a neighbor, you say hi, you smile. That's how to do it. You don't frown your face and just be mean to everybody. Constantly having parties, constantly making noise, don't say hi to anybody, very arrogant, self-centered. No, you're living in a community. So if Amazon drops a wrong package in front of your door and you see the address, it's for your neighbor, the best thing is not to throw it in the trash. You can knock on their door and give it to them that, oh, looks like they made a mistake. I mean, just be a human being. Nobody has to teach anybody how to be a human being, right? Be nice to your neighbors. During Halloween, put out candy, put out chocolates for the kids in the neighborhood. Some of the homes, they will never put out candy. And so if USCIS goes to such a home and they ask about you, they won't say nice things about you. You see, so your employer also, who you work for, you gotta make sure you're doing your work well. You come early, you leave late, put in your best. Do it as if you are doing it for your own business or for yourself. Because your employer, the person who employs you, they can be asked. Well, you should first of all ask them for testimonial letters so that you can avoid neighborhood investigation. Because if they do neighborhood investigation, guess what? USCIS will now choose who they are going to ask, and you don't have control over that. Maybe the particular neighbor they're going to ask, you have a problem with him, or the particular co-worker, you have a problem with them, and that's going to be a problem for you. So you see, this is a tactic, like a military tactic. Before they stop you, you stop them. You go in advance and you present the best possible testimonials from your point of view so that you stop them in their tracks from going behind you and picking somebody who hates you and is already waiting to destroy you, right? Now, when they contact, well, these testimonial letters, they want these people to provide substantiated information about you, including the requirements for naturalization. Again, residence, your good moral character, your criminal issues, your behavior, your general conduct. I'm sorry. Now, step 3, if such evidence is not contained or they still don't have it on your file, then they will order a neighborhood investigation. That's when they will make an individualized discretionary decision, say, okay, let's go in and investigate this person. So in order to avoid this, you have to proactively submit a lot of evidence, and you have to submit relevant, probative, credible evidence. That's the trifactor standard for submitting immigration evidence. It must be relevant, it must be probative, it must be credible. I won't go into that today, but the evidence has to have some characteristics. You don't just submit anything and everything. Okay. All right. So that's when they'll decide to do the neighborhood investigation. You want to avoid this, you got to make sure that your citizenship application is well submitted. All right. Now let's move on to the next topic we have to discuss. We have a bunch of them. The next memo we're going to be discussing is something called false claim to US citizenship. This we were supposed to have discussed it last week, but we ran out of time. So we still have some time today. We're going to be doing false claim to US citizenship. Guys, this is one of the most severe, or I should say, harshest bars of inadmissibility you can ever get. It's not only a ground of inadmissibility, it's also a ground of deportability. You don't want to be caught with false claim to US citizenship. Take it from me. If you are caught with a false claim to US citizenship, you can never become a green card holder. And if you are a green card holder, you become deportable, meaning you'll be sent to immigration court for deportation proceedings. There's no waiver, there's no forgiveness. It's like blasphemy for Christians. There's just no forgiveness. There's a very narrow exception for minor children, which I believe we can also discuss today. Let's look at the memo here. Yes, false claim to US citizenship. This memo was updated, or this was released on August 20th, 2025. And so they've revised the policy, but pretty much it goes on to say that, let me see here, hold on, let me pull this thing up from here. False claim to US citizenship is to claim that you are a US citizen when you are not, for the purpose of getting a benefit under law. Okay, so the definition under the Immigration Nationality Act Section 237, that covers the deportability, and the INA 212 A6CII covers inadmissibility. Any alien who falsely represents or has falsely represented himself to be a citizen of the United States for any purpose or benefit under law or any federal or state law, you are deportable, you are inadmissible. Okay, so it's a double issue right there. Now let's come here. Okay. Congress provides a specific ground of inadmissibility to address when an alien or a non-citizen falsely claims to be a US citizen for any purpose or benefit under law or under federal or state law. So practically speaking, for example, if you're applying for a job and then you say that you're a US citizen so that you can get the job, that's false claim to US citizenship because it was for the purpose of getting the job. If you're coming into the United States, let's say you are coming into Canada, you are in a car, and the Customs and Border Protection officer is asking, are you a US citizen? And you say, yes, I'm a US citizen. He says, okay, just go. And he waves you through. That's a false claim to US citizenship because you did it, you falsely lied, or you lied that you were, you cannot falsely lie, I'm sorry, because is there a truthful lie? I don't think so. So you falsely claimed or you lied that you were a US citizen when you were not. And it was for the purpose of getting a benefit, being allowed entry into the US. That can put you in big trouble. If you are found inadmissible, you are permanently barred. You can never get a green card. There's no waiver available. There's a narrow exception, as I mentioned, for non-citizens who are permanently living in the US before they turn the age of 16. We'll look at that closely. So let's look at matter of Zhang. BIA is a Board of Immigration Appeal case. And this case, my goodness, guys, it's an old case. I've read it several times. Let me tell you what happened in that guy's case. Some people are very bold. You guys are going to be surprised. Some people are very bold. Let me tell you what happened in that case. Bear with me here. So Zhang, he was called Zhang. He was a green card holder from China. And guess what he did? He was found removable or deportable under law for falsely claiming to be a US citizen. He went and bought a certificate of naturalization from an immigration officer. Can you imagine that? So USCIS is the immigration office that takes care of affirmative applications. In the past, they were called, that office, USCIS was called INS, Immigration Nationality Services, INS. And so the Zhang man went and, maybe he had a friend, I don't know, a friend who worked with INS or USCIS. And he told the guy that, look, just hook me up. I'll buy a citizenship application, a certificate of naturalization, the form N550. That's the certificate you get after you have been recommended for citizenship and you've sworn your oath and everything, meaning you are now a US citizen. You are given this certificate of naturalization. And you use that certificate to apply for a US passport. You use that to apply for whatever you need to show that you're a US citizen or your passport card. This guy went and bought it with money. Now, that USCIS officer was later convicted for selling such certificates. This was the business this man was into. You have been employed by the US government. You are in USCIS helping with cases, and then you are behind closed doors, you are selling certificate of naturalization documents. I don't know how much he sold it, he bought it for. I don't know if they said, and I can't quite remember, but he bought this, and so they said, okay, you are deportable. They took him to immigration court, wanted to deport him. And this Zhang said that he's not deportable. He tried to argue and said that, he's just not deportable because he's not deportable. And the BIA disagreed with him and said, you are deportable. And during the case, they discussed whether the statute that makes you deportable for falsely claiming to be a US citizen requires you to know or to willfully lie. Okay, so here's what it means. Even if you make a mistake by falsely, you claim to be a US citizen, even if you didn't know you were making such a claim, you didn't know that you made such a claim, you are still liable under this law, because the plain language of this law does not show. Oh my gosh, let me scroll down. It looks like I'm just stuck here. Let's scroll down here. This is in my iBooks. Okay, let's go here. Okay. So in the case, they discussed whether did you have to know you were making such a false claim, or you didn't have to know. Let me pull that up. I don't know why my screen is frozen suddenly. Let's see if this will work. Okay, there you go. Oh. Okay, let's go to this here. All right. Let's come here. All right. So the Zhang man who was placed in removal proceedings, he was arguing that he's not removable because he's a U.S. citizen, and that he always believed that he was a U.S. citizen. Do you see the argument he was making? He believed that he was a U.S. citizen. But how can you believe you're a U.S. citizen when you know that you've bought the certificate that makes you a U.S. citizen? I think he just didn't have any defense and was trying to play smart. In response, DHS also said that no, the statutory language of Section 237A3D, it doesn't require intent or a culpable mental state, a guilty mind before you can be said to have falsely claimed to be a US citizen. They went on to look at the other sections of law which is identical to the section under which this man was being removed from the US. And if you look at the legislative history, it shows that at some point, for example, the law that makes you inadmissible under misrepresentation or fraud, there is that scienter element or the intent element. When you are going to be charged with an inadmissibility because of fraud, the law requires that you must have intent to deceive. Okay. But when it comes to false claim to citizenship, there's no such intent requirement. The problem, or the crime, I should say, of false claim to, well, it's not a crime, but the violation or the immigration violation of false claim to US citizenship is complete upon its performance. It's not dependent on your state of mind or whether you knew or you didn't know. So when Congress uses a specific language in one part, but it leaves it out in another, courts presume that the difference was intentional. Okay, so let me see here. You see, so it says here that let me go to the keys. I'm sorry, I just have so many screens that I'm using. So please bear with me. Okay, there it is. All right, let's move on to the next page. I think it will have what I'm looking for. Let's go to page 3. Okay, now it says the plain language of this section does not require an intent to falsely represent citizenship status. So you don't need to have an intent that, oh, I'm falsely claiming to be a citizen. Even if you believe you're a US citizen and you are not, and you go and say you're a US citizen for the purpose of a benefit, you are liable under this violation. All right. So this is the other distinction I was telling you, where Congress includes particular language in one section of statute, omits it in another. It's generally presumed that Congress acts intentionally and purposely in the disparate inclusion or exclusion. A negative inference may be drawn from the exclusion of language from one statutory provision that is included in other provisions of the same statute. So that is just the interpretation of the fact that another statute specifically required a knowledge or willful intent to deceive. And this false claim to citizenship does not require any intent at all. So that's why you have to be even careful. You cannot even make a mistake and go and claim when you are filling an I-9, where you are supposed to show what your status is. If you make a mistake and tick US citizen, and you get a benefit of a job, you are liable under this ground, and you can be deported if you're a green card holder. You can also be barred forever from getting a green card if you are a non-immigrant or undocumented. Okay. All right, let's go on. Let me see. I think I may have some other points that I want you to note as well. Yes, so the absence of waiver language means no waiver exists for this, unless of course you are a minor child, and this is a very specific exception. Let me see if I can find it in the case law directly. Okay. Well, let's just move on. Let's just move on. All right, let's move on to, so yeah, this is the new update. Pretty much this has always been the case, but now they've included it in their policy manual. They've clarified it. You are not required to know before you make a false claim to US citizenship. Even a mistake of false claim to US citizenship is a big problem. So just be aware, please. If you are filling out paperwork, you have to be extra careful. Don't make any mistake. Now let's talk about other live updates. Let's talk about alligator. Oh my gosh. Okay, so no, this is not. Let's talk about other live updates here. There's so much happening. Alligator Alcatraz, you know, that detention center where people have complained that there's a lot of inhumane conditions. A judge, we discussed it last week, a judge has told them to dismantle it next 60 days. They shouldn't bring new people in there. I believe apparently there were about 1,000 detainees there. About 100 of them have already been deported from the US from Alligator Alcatraz. And now there's just about 300 people left in Alligator Alcatraz. The Trump administration and I believe the state of Florida filed to the judge, Kathleen, and they asked her to stay the order, the closure order. And the judge said, nope, she's denied the request. She's denied the request and said she stands by what she said, that Alligator Alcatraz should be dismantled moving forward. They should keep transferring people out of that detention center to other detention centers. Apparently, there have been buses going on, and they are phasing out people are no, they're just reducing the number of people at the alligator Alcatraz, and they've spent over, I believe, according to reports, over $250 million on this alligator Alcatraz. Quite unfortunate that they had to spend the money on this, and in the end, it was just a waste. Let's see how that goes. Now, the next thing is we shared this across our social media platforms as well. The EOIR now, well, Executive Office of Immigration Review, immigration courts are backlogged. There's now currently about over 4.1 million cases pending, never been seen in US history. And over 100 judges, immigration judges, have either been fired or they've left. And so the backlog keeps growing. And now, previously, if you wanted to be an immigration judge, you had to have 10 years of experience as the Department of Justice immigration attorney. But now there's no such requirement. Any licensed attorney, you can apply and become an immigration judge. I mean, how incredible is that? Immigration is so complex. I just don't know how anybody without immigration law experience can become a judge. But well, that's what's happening now. They are appointing temporary immigration judges, and they've just broadened the pool because they desperately need immigration judges. And these temporary immigration judges, they're appointed for 6-month terms. It can be extended indefinitely. And let me again talk about the fact that previously eligibility for, if you wanted to be an immigration judge, you had to be either a former immigration judge or appellate immigration judge, or you were an EOIR administrative law judge, or you were an administrative law judge from another federal agency, or you were a Department of Justice attorney with at least 10 years of immigration law experience. Now, all those things have been waived. Just any licensed attorney. So they're accepting resumes. If you're interested and you are good, absolutely go for it. All right. Apparently, they said they're going to be training them as much as they train other immigration judges. This final rule was published, I believe, yesterday, August 28th, 2025. It's a final rule published in the Federal Register. So it is a rule now. The temporary immigration judges are different from the permanent immigration judges. Temporary immigration judges are appointed by the Executive Office of Immigration Review Director with the Attorney General's approval for a 6-month renewable term. And immigration judges are appointed directly by the Attorney General. And it's a career federal position, usually after a competitive hiring process. So this is incredible. I don't know how these temporary immigration judges are going to be adjudicating complex asylum cases, complex cancellation of removal cases with no immigration experience. It's mind-blowing that this is where we've gotten to. This is why if you are going into your removal hearing or you have immigration court, you have to make sure you have an attorney that knows what they're doing. Because to be honest, even the judges sometimes get it wrong. Everybody can get it wrong, right? But you need advocacy, proper advocacy. Let's move on to student visas. Student visas, there's an update there. They are going to be, there's a proposed new rule also to reduce to change duration of status for student visas and J exchange visas to definitive. So instead of having DS, they're going to have a fixed end date. There's also a 30-day grace period, moving or reducing it from 60-day grace period to now 30 days grace period. This rule is not final, it's just a proposal. You can actually make comments and either support it or say why you don't support it. We shared the link to the Federal Register publication. If you click on it, the first few pages talks about how you can make a public comment. So take advantage of it and make a public comment. It's only a proposed rule. I'm sorry, and it will not take effect until DHS reviews all the public comments and they will submit a final rule for OMB review. Then it will publish a final rule in the Federal Register notice with effective date. Um, I'm sorry. The public comments is due by September 27, 2025. And this rule will likely not go back to be retroactive. It will be retrospective. It's going to look, or prospective. It will look forward. So, but let's see how everything goes there. We wanted to discuss Kilma Abrego Garcia. I actually spoke with BBC this week on Kilma Abrego Garcia's deportation. It was on their BBC News Day show live on Tuesday morning. So I wanted to discuss Kilma Abrego Garcia, but we've run out of time. I think I need to do an entire session on Kilma Abrego Garcia, but that is just another case that is just going very badly. It looks like there's just a lot the government wants to prove with that case, and they will not stop until they have that man deported. But there's just too much to unpack there, so we will leave that for today and see if we have any questions on YouTube, Facebook, Instagram. Drop your questions. Let me see if I can answer questions for you. On Instagram, we have Abimelakailu. He says, what do you advise for green card holders to apply for citizenship or to renew their green card? The advice I will give will be based on your personal circumstances. After I review your history, what you've done, what's going on, that's when we'll be able to give you advice about should you apply for naturalization? Are you eligible, or you are not eligible, so continue to renew your green card? And I'll say this, we've been saying this from day one. The advice, I would say general admonition. If you are eligible for US immigration benefits, the best time to apply for it is now, when you are eligible. And eligibility is not just you waking up in your bedroom and feeling like, oh, you know what? I feel like I could make a really lovely US citizen. So I'm applying for US citizenship. It's about actually understanding what is the process of review that government goes through, going through such rigorous, the rigors of the screening and making sure that an immigration attorney actually tells you you qualify. We've had people make devastating mistakes on these type of applications, and US citizenship application or naturalization is the most important. As an immigrant, that is the highest immigration status you can attain. And so I wouldn't take it lightly. Contact a qualified immigration attorney. You are free to contact us and we'll review, have a one-on-one with you, and we'll let you know, do you qualify? No, this could be an issue. Here's how we can resolve it. No, this is you're going to have to wait maybe 6 months. Let's clear this. And there's a lot of things we can do to give you proper advice based on what's happening, what's going on, current laws, and then we can give you solid advice on moving forward on whether you should apply or not. But generally speaking, if you are eligible, you should apply. But make sure that determination of whether you're eligible or not is even accurate. That's where the problem is. You have to have an accurate assessment of whether you are eligible before this general admonition will apply, that if you are eligible, then you can apply. But are you eligible? Are you really eligible? That's the question. Okay, let me see if we have let me see if we have more questions here. Let me go to TikTok. Okay, Okoro King says, if I'm denied citizenship and I'm not able to challenge the denial within the time frame given, can I still challenge it, or it's over for me to file a challenge? It is over. Usually when you're denied citizenship, you can file the N336 notice of rehearing to see if there was a mistake that was made. If you feel like, oh, I want to challenge it, there's a time frame. I believe it's a 30-day period. Well, there's some number of days you have to be able to challenge these things, right? Because all of this is based on the legal principle res judicata. Pretty much like letting sleeping dogs lie. Once a matter is done, it's done. You cannot, like, imagine if you get denied US citizenship and then 5 years later you're like, these people lied about me. They said that I have a criminal issue and I don't have a criminal issue. I want to challenge them. Then another person wakes up 10 years later. I'm not happy with you because you denied me. You shouldn't have denied me. There will never be an end to litigation. Yes, so it's a 30-day calendar period. You have 30 days from the denied citizenship to file a notice or request a rehearing on a decision in your naturalization application under Immigration and Nationality Act Section 336. Okay, so what I would recommend is that you can contact us. Let's review what was the reason your naturalization was denied. And instead of challenging because you're out of time, you can refile. A refiling is always possible, but be careful about refiling because there's a February 28th, 2025 NTA memo that was issued. We discuss it right here. Now, if you apply for naturalization and it's denied because you're deportable, you will be issued with a deportation notice. You'll be sent straight on the road to immigration courts. There'll be no curve, no bend. You find yourself in front of an immigration judge to answer to why you should not be removed from the United States. So there is the legal principle of res judicata. Let sleeping dogs lie. There must be an end to litigation. So you cannot wake up and then just decide that at any time you want to you don't you don't go with the time frame that you've been given to challenge a case. You just want your own time frame. It doesn't work that way. Res judicata is Latin for a matter judged. A matter judged. A matter judged cannot be relitigated. So you can't come back later when you are out of time, right? When you're out of time, you're out of time. There's a statute of limitations. When you're out of time, you're out of time. You have to follow the procedural rules for trying to challenge a decision. It's not really serious, as I mentioned. If you are eligible, you can do a refiling, but you have to be careful because now a denial based on deportability will trigger a deportation notice. Okay, so you want to be aware of that. Let's see if we have anything on TikTok. Educe says, is it Educe or Educe? Who says, please, is it advisable for B1, B2 to travel during what's happening? Oh, absolutely. So many people are coming in each day, each day, each night. Okay. I'm hosting somebody who just came in today with a B1, B2 visa, despite all that's happening. It's possible. It's possible. You just have to be extra careful, have your things in order. And if you are worried, speak with an immigration attorney before you travel. You have to understand the purpose of your trip, how long you're going to be here. We have a lot of videos on these things. You have a return ticket, you have a job to go back to, you don't have any red flags, like you stayed 5 months, 3 weeks the last time, things like that. Blackberry 23987 says, what do you know about the approved I-130 with pending 601? We know a lot about that. Guys, let me pause to say, if you haven't followed our social media platforms, follow now AK Poku Law across social media platforms. Approved I-130 with pending 601. Is it, what is the basis of the 601? Inadmissibility waiver. Do you have a fraud issue, misrepresentation issue, criminal issue? The 601 is, and you guys, we shared a success story just this week or end of last week. We actually got a 601 waiver approved in 7 days. The evidence is on our social media pages, and the person had fraud issues. We filed it, thousands of pages of evidence, and it was approved in 7 days. Typically, 601 waivers take about 3 to 4 years. But yeah, if you have a family member or whoever, if you have a petition pending, you are trying to become a green card holder, and you have something called an inadmissibility. It could be based on criminal issues. It could be based on misrepresentation. It could be based on fraud, health issues, public charge rule. Then you are inadmissible. Now, some grounds of inadmissibilities have forgiveness. The law says you can be forgiven if you have this ground of inadmissibility. If you can't be forgiven, if it's a waivable offense, then you can file a 601 waiver to overcome that ground of inadmissibility. And so if you do have an I-130 pending and you have that, the 601, it has to be approved first before you can apply for your green card. On the other hand, there's a difference between having an I-130 pending and an I-601A waiver for unlawful presence. Now, the I-601A waiver people are the ones that the government is saying they can put them in deportation proceedings, because those are typically people who came in unlawfully, they entered the US unlawfully, or they have some type of unlawful presence. Maybe they even came in lawfully, but they've overstayed, they've accrued unlawful presence, and they're trying to adjust their status or get green cards to the preference immigrant category. Then they need a 601A waiver where they'll go back to their home country and do consular processing interview. So please just contact us so we know a lot about it. That's all we do at this law firm, immigration. And so we're filing hundreds and hundreds of packages every week. And so we can help you. We understand what's happening. So just contact us, AK Poku Law. Yes, if you filed a case, you haven't heard from them, make sure you contact us. Let's look into it for you. We've had situations where people filed cases and they didn't even know that what they've done, everything was wrong. We've been speaking with some of them, and it's some of them is not good. You can get lucky if it's filed properly. It can get approved without immigration involvement, but if you have to wait for 3 years for the case to be adjudicated, and at the end of 3 years or 2 years, it gets denied, you have to start all over again. And that family separation really destroys a lot of things. So make sure you contact us. If you have any questions, contact us, AK Poku Law, 802-780-0564. All our information is, you Google us, you'll find our information, and our information should be on the screen as well. Let me see here. Do we have, yeah, our information should be on the screen as well. Yeah, right here. So you can feel free to contact us if you need our help. If you guys don't have any more questions, then we will call it a day, and hopefully we'll see you all next week, God willing. If God gives us life and health, we'll be here. And guys, if you see our posts, please engage with our posts, like, comment, share. And if you haven't followed us across all social media platforms, please follow us, AK Poku Law, and we're doing our best to keep you informed, keep you educated. It's a big learning curve for all of us. So much happening, and we're trying to stay abreast. At the same time, trying to stay hydrated, trying to advocate for our clients, trying to do actual legal work. So it's a lot on our plate. So we hope you appreciate it. Well, thank you for joining again. I wish you all a great rest of your day and weekend. Okay. Take care, and I'll see you soon in our next video session. Bye. Take care, TikTok. Bye-bye, Facebook, and